Dear colleagues, I would like to welcome all of you, and I would like to start. I know that we normally wait a little bit longer for all those who are coming usually late. We just finished far away from here a joint meeting with Petty Committee on the transparency in the Council and the report of the European Ombudsman, so that's why some of us can be late. But I think we start. So I would like to start with the adoption of first of all, to inform you that the meeting is web streamed. Then on the adoption of agenda point, I would like to remind us that the final version of the agenda has been circulated on 17th of September, and there are no objections to the agenda, which I don't see. I consider the draft agenda adopted. I have no chair's announcement under point 3. I have, however, chair's announcement concerning coordinators' recommendation under point 4. This relates to the decisions which were endorsed by the coordinators during the meeting of the 10th of September. So what has been proposed is to give the report to opinion to LIBE on the proposal for regulation of the European Parliament and the Council establishing the Rights and Values Programme. This would be assigned to the Greens, and Josep Maria Terricabras was proposed as rapporteur. Second point, with regard to the opinion to the budget and econ joint interim report on the establishment of the European Monetary Fund, this opinion will be assigned to the chair of the committee. Then we have decided or recommend as coordinators meeting not to give opinions to the reports on the discharge 2017 EU general budget. Next point, with regard to the motion for resolution on calling for national parliaments to be given a greater role in transposing EU directives, which is a motion by Joël Mellin, we decided to transmit this motion to the rapporteur on the state of play of the debate on the future of Europe, Ramon Jauregui Atondo, for further consideration. The coordinators meeting also agreed to maintain the hearing on constitutional perspective of EU's social dimension in the context of the debate on the future of Europe, and to organize this hearing within the AFCO meeting on 27 November this year. We also recommend to you, to committee, to organize a European Youth hearing with the AFCO committee during its meeting of 27 November, to organize a hearing on 10th October in the framework of AFCO implementation report on the treaty provisions on Parliament's power of political control over the Commission. This is related to Mercedes Bresso report. And then through the written procedure, a mission to Paris was cancelled, as we have agreed that if there is less than 3 members willing to go, we will cancel, and we had only one person that the Secretariat was informed about, so it was in written procedure, it was cancelled. And then with regard to the proposal for the modification of the regulation of the European Parliament and the Council amending regulation as regards a verification procedure related to infringements of rules on the protection of personal data in the context of elections to the European Parliament, coordinators propose, following a written procedure, also to appoint Mercedes Bresso and Rainer Wieland as co-rapporteurs. So if there are no objections to the recommendations by the coordinators meeting, I would consider those recommendations as adopted. And I would like to move to point 5 on the agenda, which is my report, my usual report on the state of play of Brexit negotiations. I would like to inform you that we had in September 3 meetings always with debriefings from Chief Negotiator Michel Barnier on the state of play of negotiations. Next meeting will take place tomorrow. And additionally, just of the most important meetings that I had as a chair of AFCO, regarding people who wanted to speak about Brexit. I had a meeting with UK Minister David Lidington explaining the major lines of the UK proposals in the context of the withdrawal and future arrangements. I also had a meeting with permanent representative of Denmark to discuss also the progress, the perspective of the Danes as it comes to the progress in the withdrawal negotiations. Then I had a meeting with Luxembourg Brexit coordinator on main concerns and expectations of Luxembourg in relation to Brexit. And then I also had a meeting with Roger Casale, founder of the New European Associations, on issues related to free movement after the withdrawal of the UK, and in particular the possibility of a green card to be issued to British citizens established in the territory of the EU27 by Brexit date. I think we might have, if we find time, also the possibility for the committee to listen to Monsieur Casale. Now, with regard to my perception of the current state of play, I would like to repeat that Michel Barnier has been briefing the Brexit steering group on the progress of negotiations with a sort of growing expression of a sense of urgency. The Salzburg meeting, as you probably also took note of it, was an important meeting that brought also a sort of new perspectives also coming visibly from both sides. And it is clear today that October Council, the 18th of October, will be a decisive moment, because the sufficient progress by that time would allow then to have additional November summit to finalize and formalize the deal. So clearly the next 4 weeks will be fundamental also for the whole process. We also understand from what Michel Barnier has been informing us is that during the October summit, the evaluation of the progress will come from him as the chief negotiator, and this will be the basis for further decisions on the meeting in November. It doesn't come probably a surprise to you. We repeatedly hear from negotiators that the most challenging, outstanding issue is the backstop for Northern Ireland, and also future solution for Irish border. But there are still other separation-related issues in the negotiation. Especially difficult seem to be also the geographical indications issues. And then, as you probably also know, a governance system of the withdrawal agreement has not been yet finalized in terms of how this system should look like, and especially the role of the ECJ. And of course, the political deliberations related to the political declaration on the future relationship is a big open issue, and also a rather urgent one. So we hope that in the weeks to come we will see progress on those most difficult issues, and then also the finalization of the smaller issues belonging to the withdrawal agreement. Regarding the future relationships, those of you who are especially interested, probably would encourage you to look also into white paper and the Chequers document, and also to read maybe on current and frequent statements coming from Michel Barnier, because we, I think, today see clearly that part of the future element of the future framework will be relatively easy to agree upon, and this is issues related to especially external policy and defense policy cooperation, this area of security, external security, and maybe more challenging but also important and relatively easier will be also issues related to the cooperation in the area of the security of citizens, more internal security. But then, of course, all the economic part of it is still a big open issue, which will require probably urgent and intense cooperation and negotiations in the weeks to come. And also I would like to inform you that most likely in the second meeting of October, second plenary of October, there will be the possibility for a Brexit steering group to table a resolution on citizens' rights. I also assume that at the beginning of October, the Brexit steering group might also make a statement regarding the progress on the negotiations. So that would be this under point number 5. So that allows me to move to point number 6, which is our hearing. And I'm very happy and pleased to welcome 2 professors, René Repasi, who is a sort of scientific coordinator of the European Research Centre for Economic and Financial Governance of the 3 important universities, I understand, of Leiden, Delft and Rotterdam. And we also have Christophe Hillion, a professor of European law at 2 universities, also Leiden, but also universities of Oslo. Both experts are well known to us because we already listened to them over the last 2 or 3 years. And today we have invited both professors to hear from them not sort of a political assessment, because that's, I think, if I can say, up to us to decide, but to listen to you and to your preliminary legal technical assessment of where we are and how do you read what we already have as withdrawal agreement, because this will be very important for the committee when we will be approaching the moment where the consent procedure will have to be taken up and prepared. So it will be up to you which issues you will pick up for your assessment. We hope that there will be both a general assessment of the draft withdrawal agreement from your perspective, but we, as you can imagine, we are specifically also interested as the committee in the sort of Irish border issue, if I can say it this way. So whatever you can share with us on this part of the withdrawal agreement, which is the protocol, we would be also probably, it would be also very, very welcome. So I think you feel who should start better from the point of view of the logic of So we leave it up to you, but I will need this information. So René Repasi, Professor Repasi starts the presentation. The floor is yours.
Yeah, good afternoon, Madam Chairwoman, Professor Hübner, dear members of the Constitutional Affairs Committee. I would like to thank you for inviting me to participate in this hearing on the withdrawal agreement between the EU and the UK. As was already mentioned in the introductory words, it's quite a broad topic. And we discussed beforehand to focus on which parts. And it was decided that I should focus more on the Northern Irish issue, so the Irish border issue, and to the extent that it will have an impact on internal market, and by that also with a view what that could mean for the future trade relationship. Now, as a preliminary note, giving a substantive legal input in matters relating to Brexit is always a difficult task, as even now, more than 2 years after the referendum, we still have to deal with a moving target. The basis for any assessment is a draft withdrawal agreement that was published in February. Given the statements made by the heads of state or governments at last week's European Council meeting in Salzburg, we are still far away from a deal that would convert the draft text into an actual withdrawal agreement proposal submitted to the European Parliament for obtaining its consent. Nevertheless, it's worth to have a closer look at the draft text and the proposals that were made in particular by the UK government. The issues that were to be solved by a withdrawal agreement are citizens' rights, financial arrangements, the governance, a transition period, and avoiding a hard border between Northern Ireland and the Republic of Ireland. As mentioned in my introductory statement, I would like to focus on the latter point, the Northern Irish question. I will here first look at the draft protocol and assess it against two benchmarks. Does it avoid border controls on the Irish island? And does it preserve the integrity of the internal market? Having discussed these points, I will second address the question what this protocol would mean for the negotiations of the future trade agreement if it entered into force as it is proposed. Third, I will take a look at the alternatives to the draft protocol, in particular those presented by the UK government, and will fourth discuss the suitability to avoid a hard border. Fifth and finally, I will conclude on these alternatives and on the draft protocol. Before turning to the details of the draft protocol on Northern Ireland, let me quickly recall the political parameters well known to you, defining the playing field within which a viable deal between the EU and the UK can be struck. There is first, Brexit means Brexit, according to which the UK has to leave the financial, legal and institutional framework of the EU in implementing the people's will. Second, there is the EU's imperative not to divide the integrity of the internal market. And third, a hard border between the Republic of Ireland and Northern Ireland with border controls may in no way be re-established. Finding an answer to the Irish question that accommodates all these interests amounts to cutting the Gordian knot. How can the integrity of the internal market be upheld without setting up border controls in the event that Northern Ireland is to leave the EU? Let's have a look now at how the draft protocol addresses this issue. The draft protocol implements the so-called backstop solution, which means that it only applies unless and as long as both the UK and the EU do not find another solution to the Irish question in a future trade agreement. The protocol shall apply as from the end of the transition period, which is supposed to be on 31st December 2020. The draft protocol is subdivided in 5 chapters dealing with rights of individuals, movement of persons, the common regulatory area, institutional provisions, and final provisions. So let's have a look. Article 1 incorporates parts of the Good Friday Agreement into the draft protocol. Paragraph 1 of this article refers to the chapter... Okay, dann etwas langsamer. So, paragraph 1 of this article refers to the chapter on rights, safeguards and equality of opportunity in the Good Friday Agreement. This chapter deals with human rights and with economic, social and cultural issues. Most notably, the chapter requires from the UK to make the European Convention of Human Rights legally binding in Northern Ireland with direct access to courts and remedies in case of breaches. Under the draft protocol, this obligation will become part of the withdrawal agreement, and the EU will act as a guarantor for this obligation. It is worth noticing that many rights foreseen by the agreement in 1998 could rely on the enforceability of EU law, which is directly applicable in both Northern Ireland and the Republic of Ireland. The withdrawal of the UK from the EU may therefore deprive citizens from actual legal protection of rights that the parties under the Good Friday Agreement are committed to respect, because directly applicable EU rights won't be available in Northern Ireland anymore after Brexit. Article 1, paragraph 1 responds to this threat by including a legal obligation for the UK that there would be no diminution of rights. This must be understood as an obligation for the UK to uphold the EU acquis and its free movement rights in its content and in its enforceability on the territory of Northern Ireland, to the extent that they cover the commitments under the chapter on rights, safeguards and equality of opportunity in the Good Friday Agreement. What remains vague is the meaning of dedicated mechanisms through which Article 1 is supposed to be implemented. This reference must be understood as excluding a direct effect of this article, so that citizens could rely on it in front, so that citizens cannot rely on it in front of national courts. If this understanding is correct, It would reduce the practical importance of this article significantly. Chapters 2 and 3 of the draft protocol must be read jointly. Together they form the successor of the EU internal market for Northern Ireland. Most strikingly, both chapters read together show a significant deviation from what is the integrity of the internal market. The free movement of workers, the freedom to provide services, and the freedom of establishment are somewhat dealt with in Article 2, which integrates the common travel area into the draft protocol. The free movement of goods is addressed by the common regulatory area in Chapter 3. The free movement of capital is not mentioned anywhere. Checking these chapters against the existing internal market law reveals significant gaps. When it comes to the first set of free movement rights, the reference to the common travel area has not the same quality as directly applicable free movement rights for persons under EU law. The common travel area is based on a mutual understanding between the UK and Ireland to conform immigration laws to each other so that any border control is unnecessary. The creation of the common travel area dates back to the year 1923. Traces of it can be found in UK and in Irish national law. Yet, its purely political nature can be seen in the period between 1939 and 1952, in which controls of passengers between the entire Irish island, including Northern Ireland, and Great Britain took place. If I may say so, in this period there were obviously UK prime ministers agreeing with some sort of separation with border controls in the Irish Sea between Northern Ireland and the rest of the UK. Border controls were again abolished in 1952 based on an agreement between Ireland and the UK, which was deemed by Irish officials as, I quote, entirely informal. A joint statement by the UK and Irish Minister for Immigration on the Common Travel Area of 2011 states explicitly that, I quote, it is not intended to create legally binding obligations nor to create or confer any rights, privilege or benefit on any person or party, private or public. All in all, Article 2 of the draft protocol and its reference to the common travel area means, on the one hand, legally less than the free movement of person rights foreseen by the EU treaties, as the actual legal meaning of this area depends entirely on domestic law, which after Brexit may deviate from each other. On the other hand, if the UK adopts tougher immigration rules than the EU, to which Irish law is bound, and if the UK sticks to its commitment not to establish a hard border between Northern Ireland and the Republic of Ireland, it can only return to the precedent of the time between 1939 and 1952, during which it established border controls on the Irish Sea. Turning to the free movement of goods, the draft protocol creates in Chapter 3 a so-called common regulatory area, a creature unknown in EU law. Article 4 of the draft protocol copies and pastes Article 30 TFEU on the prohibition of custom duties and charges having an equivalent effect. It incorporates Articles 34 and 35 TFEU on quantitative restrictions and measures having an equivalent effect. It transfers Article 110 TFEU on tax restrictions for goods into the common regulatory area. It extends the scope of application of the Union Customs Code to the Northern Irish Territory and qualifies the UK customs authorities in Northern Ireland as custom authorities of an EU member state. Whilst this appears to be a copy of the internal market to be applicable in Northern Ireland, a closer look reveals that this is not entirely true. The secondary union acquis is only covered by the draft protocol to the extent that a specific legal act is mentioned in annexes to the protocol. These annexes are at least publicly not yet defined. This legislative technique reminds of traditional trade agreements with a so-called positive list approach rather than of an integrated internal market for goods. This has two consequences. Firstly, the European Court of Justice will have to decide on the appropriate level of protection in Northern Ireland. And second, there will only be a dynamization of EU legal acts mentioned in the annexes. Any other new legal act after Brexit would have to be included into the annexes following a formal amendment procedure, which means after approval or by the UK. Regarding the powers of the Court of Justice, it has to be seen that in the EU, secondary law in the field of free movement of goods mostly defines common protection standards. When not being covered by a secondary legal act listed in the annexes, there will be uncertainty with regard to the legality of a particular protection standard in Northern Ireland. Legal certainty that is achieved within the EU by a secondary legal act has then to be established by the European Court of Justice on a case-by-case basis. According to Article 11 of the draft protocol, namely, the Court remains competent for the interpretation of the free movement provisions in Article 4 of the draft protocol and has therefore to decide whether a particular protection standard is justified under the requirements set by the protocols, which equal those set by EU primary law. To complete the comparison with the EU internal market, one has to look at competition law. Strangely, the draft protocol only incorporates state aid law, whilst it leaves the prohibition of cartels and the abuse of dominant positions out of the protocol. Having compared the provisions of the draft protocol with the EU internal market, one can draw the following interim conclusions. The draft protocol creates a customs union between the EU and Northern Ireland and an internal market in relation to goods, albeit incomplete, as only a limited number of EU secondary law will be transferred into the common regulatory area. There is no equivalent for the freedom to provide services, the free movement of workers, and the freedom of establishment. Only the free movement of persons aspect of these fundamental freedoms is guaranteed to the extent that it is covered by the common travel area, which, as mentioned, does not include any enforceable individual rights. The free movement of capital is not mentioned at all. We can therefore conclude that the EU in this draft protocol already gave up on the integrity of the internal market. The draft protocol covers the absolute minimum that is indeed needed to avoid border controls between Northern Ireland and the Republic of Ireland with a view to goods, betting on an autonomous continuation of the common travel area on the Irish island. Since the draft protocol only enters into force after the expiration of the transition period, in case no future trade agreement between the UK and the EU was found, the consequence of this protocol would be to move the border for goods to the Irish Sea, something with which, according to Prime Minister May, no British Prime Minister could ever agree. The entry into force of the draft protocol can, as it still stands, be avoided by a future free trade agreement. The UK government has published its position with regard to such an agreement in a white paper this July. In brief, it aims at entering into facilitated customs arrangements according to which, I quote, the UK would apply the EU tariffs and trade policy for goods intended for the EU, whereas it would apply its own tariffs and trade policy for goods intended for consumption in the UK. Besides customs, the UK government seeks to establish an economic partnership with a view to goods, which would be governed by a common rulebook legislated for by the UK Parliament. For services, new arrangements are to be found, whilst the free movement of persons is to be ended. The UK government's proposal specifies that, I quote, these proposals are without prejudice to the common travel area arrangements between the UK and Ireland. If the EU were to accept these proposals, border controls would have to be established on the Irish island, whilst the facilitated customs arrangements could, provided its real-life implementation in practical, financial and tactical terms would work out, at least avoid customs checks at the border between Northern Ireland and the Republic of Ireland, the common rulebook would still make product checks necessary, as product standards in the EU and in the UK can be different, as the UK Parliament may always veto the implementation of EU standards in UK legislation. In sum, the checkers' proposals may alleviate the Irish problem, They are, however, no solution with a view to avoiding border controls on the Irish island. Before turning to the overall discussion of the Irish question, let me raise an additional point in relation to the negotiation dynamics. I believe that the draft protocol as it stands now backs those voices that are in favor of giving up the integrity of the internal market for the sake of a soft Brexit deal. When we compare the Chequers proposals only to the draft protocol, we can see that in principle, the proposals reflect the same splitting up of the integrity of the internal market as it can be found in the draft protocol. Services, persons and capital can be treated with a different quality than goods. Persons are sufficiently protected by the common travel area arrangements. In relation to goods, both the UK White Paper and the draft protocol propose some sort of customs union and common rules. Admittedly, the custom arrangements and the common rule book proposed by the UK government stand behind the model supported by the draft protocol. Yet, and this is the point that I would like to make, the uniqueness of circumstances, which is put forward by the recitals of the draft protocol, won't be a convincing argument for the British side to accept a fully fledged internal market for all 4 freedoms in the future trade agreement, whilst on the territory of Northern Ireland, only an internal market for goods has to be in place. Where do we stand? We have on the one hand a draft protocol that allows for avoiding a hard border on the Irish island in relation to goods. This is done by extending the EU customs union and significant parts of the EU free movement of goods to the Northern Irish territory, and by upholding the European Court of Justice jurisdiction in these fields in the event of a hard Brexit. As a consequence, the UK would have to establish customs borders in the Irish Sea. The same would have to happen for persons if UK immigration rules were to deviate from the Irish ones in implementation of EU rules, just as it was the case between 1939 and 1952. On the other hand, we have the UK government's proposals for a future trade agreement that would alleviate the need for border controls on the Irish island, but not completely avert it. Both solutions appear unacceptable for either the EU or the UK. Is there a third way? Well, as long as the UK wants to withdraw from the EU, there must be some sort of border. And this border will be either on the Irish island or in the Irish Sea. The hindering effects of the border on the actual movement of goods, services, people and capital could be diminished by modern border control technologies. This argument was put forward by the UK government in the Chequers proposal and was discussed by a study commissioned by AFCO in November 2017 on Smart Borders 2.0. Whilst there are doubts to the extent that these proposals are actually technologically feasible, more importantly, implementation of technology will only accelerate the border control process, but not make borders invisible. Placed in the political context of the Irish-Northern Irish border, however, it is the very presence of a border control that endangers the peace process. Even a technologically accelerated border control would therefore not be sufficient to meet the political requirements of avoiding a hard border on the Irish island. If one dismisses technological solutions for border controls between the Republic of Ireland and Northern Ireland, and if one considers the backstop solution presented by the EU as unacceptable for reasons of the unity of the United Kingdom, and if one concludes that both parties are so far away from each other with regard to a consensual solution on a future trade agreement that would make border controls between the UK and the EU unnecessary, attention must be drawn to alternatives to the draft protocol with regard to the period after the expiration of the transition period on the 31st of December 2020 and the possible entry into force of a free trade agreement. In this context, the UK government presented a technical note on temporary customs arrangements. According to this note, the UK and the EU would form a customs territory of the Union insofar as the common customs tariff or other tariff measures are concerned, without the European Court of Justice having the exclusive jurisdiction over these matters. At the same time, the UK wants to regain the competence to negotiate and to conclude own free trade agreements. In short, the UK wants to remain in the customs union without the authority of the European Court of Justice until a free trade agreement with the EU is concluded and ratified. Accepting these temporary customs arrangements would most certainly turn around the bargaining powers of the EU and the UK in the negotiations for a future free trade agreement. The UK would then basically have already achieved what it seeks to achieve, splitting up the integrity of the internal market by focusing on goods. The EU would then have to negotiate the integrity of the internal market into the free trade agreement. But besides these more political strategical considerations, the temporary customs arrangements would also not solve the hard border issue, as they do not address regulatory divergence. What are the remaining alternatives to the draft protocol? The so-called Norway solution does not appear as an alternative to the protocol, as an EEA membership of the UK might solve problems relating to the free movement rights and regulatory divergence. It would, however, not solve anything with regard to the customs border, as the EEA is no customs union. The only viable solution to me would be, the closer we get to 31st of December 2020 without a treaty, without a free trade agreement, to change Article 121 of the withdrawal agreement and to extend the transition period. In procedural terms, amending the withdrawal agreement would mean to follow the Article 50 TEU procedure. So, obtaining a qualified majority in the Council, the consent of the European Parliament and of the UK Parliament. This follows from the fact that the withdrawal agreement does not have own rules on its amendment, which means to apply the procedures of its creation to its modification. Let me now summarize and conclude. Finding a solution that avoids any sort of border controls between Northern Ireland and the Republic of Ireland, that meets the political requirements of Brexit means Brexit, and safeguarding the integrity of the internal market is a mission impossible. Solving this problem is additionally aggravated by the fact that discussions turning around it are in fact proxy discussions on the future trade agreement. Since the protocol on Northern Ireland and Ireland is supposed to be in place after the expiration of the transition period, it will be the benchmark for any future trade agreement. Avoiding a hard border in the future would mean to either align the free trade agreement with the protocol or to perpetuate the unique status of Northern Ireland. If we downscale the discussion to the mere point of how to avoid hard borders the best, the draft protocol as it stands represents the best of all available options. Yet, it only addresses the free movement of goods on the Irish island. As explained previously, the free movement of persons is, at least from a legal perspective, not sufficiently protected by the common travel area as compared to the EU free movement rights. It must be noted that the EU gave up on the integrity of the internal market in the draft protocol. I believe that this might become a burden in the future negotiations for a free trade agreement with the UK, for the simple reason that the draft protocol will serve as the benchmark for this agreement. From this perspective, it would certainly be preferable to include into the draft protocol the other fundamental freedoms as well. Saying this, I am fully aware of the fact that this would make the situation politically only more difficult than it currently is. Alternatives to the draft protocol presented so far are not suitable to avoid hard borders with the same certainty as the draft protocol and must therefore be dismissed. The only feasible alternative to me would be a prolongation of the transition period in the withdrawal agreement until a consensual solution in a free trade agreement is found. I hereby want to conclude my introductory statement. I'm very much looking forward to the upcoming debate of this hearing and the statement by Professor Christophe Hillion. Thank you very much for your attention.
Thank you very much. I immediately go to Professor Hillion, hoping that you can make it also shorter.
Thank you very much, Madam Chair, also for the invitation to be here this afternoon. I'll begin by flagging up two positive developments. First, we should welcome the fact that we have a draft withdrawal agreement, as published by the Commission earlier this year, and supplemented by a document that was published in June. After all, as we know, the withdrawing state is not under an obligation to negotiate the terms of its withdrawal. It is possible for the withdrawing state to decide to go for a hard exit. So the fact that we have a draft agreement suggests that the departing state has been willing to negotiate, and that is in everyone's interest. That's the first point. The second point is that the negotiations have actually advanced quite far. If one believes the latest figures that have been floated, we are reaching 90, if not 90% of the documents being turned into green, which means that there is an agreement on 90 or 95% of the agreement. So much for the positive comments, because indeed there are a few issues that still need to be agreed, and as we already heard from the chair as well as from René, these issues are going to be quite delicate to agree upon. And without this 5 or 10% remaining issues being settled, we are not going to have an agreement. At least if we believe first the notion that nothing is agreed until everything is agreed, which is still one of the governing principles of these negotiations. So unless we agree on this remaining 5 or 10%, then there will be no deal, there will be no agreement, and therefore we will have a hard Brexit. But then in addition to this, if you look at the nature of the issues that remain to be agreed, then you immediately see that the significance of what has already been agreed is very much dependent on the remaining issues to be settled. The remaining issues, in many respects, have a horizontal character to the effect that without settlement on these remaining issues, many parts of the agreement will simply not work. So the operationalization, if you like, of the withdrawal agreements much depends on the remaining issues being settled. So while we should rejoice to the fact that the parties have been willing to negotiate and they have been able to agree on a great deal of issues in quantitative terms, there are still some key issues that need to be resolved for the withdrawal to be soft, if you like. As a footnote, if the negotiators agree on the remaining issues, then we will still need to go through the ratification process, and as we know, it may be an uphill battle, particularly on the British side. So, having made these preliminary comments, I thought that instead of going into the technical details of the regime proposed with respect to customs arrangement or VAT or intellectual property, I would rather flag up, if not recall, what I would consider as a lawyer 3 basic conditions which the withdrawal agreement must fulfill in order to be acceptable, at least on the EU side. These prerequisites, which I'm going to flag up in a second, not only provide yardsticks to assess the draft withdrawal agreement as it stands, they should also frame the remaining negotiations and constrain the EU in finalizing the deal. These 3 prerequisites are pretty obvious, but it might be worth recalling them. The first one is that the withdrawal agreement must respect EU primary law. The second prerequisite is that the withdrawal agreement must, on the whole, respect the acquis. And the third prerequisite is that the withdrawal agreement, as paradoxical as it may sound, must also contribute to helping the unions fulfilling its own objectives and tasks. These requirements, which I will develop in the next few minutes, all stem from the treaties, the EU treaties, both from Article 50 itself, but also from other provisions of EU primary law, more generally, including the EU's objectives in relation to its neighbours. And as we know, the UK will become a neighbour of the European Union as it leaves the Union. Now, as will become apparent when I go to each of these prerequisites, there may be some frictions between what has been provisionally agreed or what remains to be agreed and those prerequisites. And this is why one has to be vigilant in the remaining parts of these negotiations. Let me start with the first one. The withdrawal agreement must respect EU primary law. That has to do with Article 50 provisions, which talk about an agreement setting out the arrangement for the withdrawal of the member state concerned. Now, importantly, this agreement is to be concluded by the Union itself, contrary to accession treaties which are concluded by the member state. So the withdrawal agreement is an act of the Union, negotiated and concluded by the Union's institutions, and as an act of the Union, it's to be incorporated in the EU legal order upon its conclusion by the Council with the consent of the European Parliament. So its provisions must therefore be compliant with EU primary law, not only the provisions, the procedural provisions of Article 50, but the treaties more generally, including the Charter of Fundamental Rights as interpreted by the European Court of Justice. While the competence which Article 50 is deemed to establish has been understood by EU institutions as very broad, remember the negotiating directives defining it as an exceptional horizontal competence, it certainly does not endow the Union with powers to violate EU constitutional law altogether. What is also important to recall in this context is that both the Union and the UK as a member state are bound by these provisions of EU primary law until the UK's withdrawal. Now, some elements of the negotiations raise questions of compatibility between the withdrawal agreement and EU primary law, as interpreted by the European Court of Justice. I will focus on one example, and that is the issue, which is still unsettled, of the dispute settlement mechanism and the role of the European Court of Justice in this context. As we know, so far, the parties have agreed that a joint committee would be responsible for settling disputes concerning the implementation and application of the agreement. But according to the proposal of the Commission, this joint committee would have the ability to submit disputes about the withdrawal agreement to the European Court of Justice, which should have jurisdiction to deal with the matter. And its rulings would then become binding on both parties, the EU and its member states on the one hand, and the UK. It's also been proposed that should a party not comply with an European Court of Justice's ruling on the withdrawal agreement, the other party would be able to bring the case to the court again. And again, its rulings would be binding on the parties. The court would also have the possibility to impose a lump sum or a penalty payment to the prevaricating state. It's also possible for the parties to suspend parts of the agreement. Now, while there may have been further development since I started to work on this, if my understanding is correct, there's still no agreement on this between the UK and the EU. And in sorting out this sensitive issues, the parties will have to consider EU primary law, and in particular, one article which is essential in framing the dispute settlement mechanism of the withdrawal agreement, and that is Article 344 of the Treaty on the Functioning of the Union. Just as a reminder, this article foresees that member states undertake not to submit a dispute concerning the interpretation or application of the treaties to any methods of settlement other than those provided for therein. Now, as you're all aware, the withdrawal agreement contains all sorts of provisions referring directly to EU rules. And that would therefore trigger a role for the Court of Justice in line with the requirement of Article 344. The Court of Justice has interpreted this provision in a very strict fashion. It has also articulated various conditions for EU external agreements or EU international agreements to establish dispute settlement mechanism. And we've seen these conditions at work recently when the Court of Justice was asked to determine whether the draft accession treaty of the EU to the ECHR was compatible with the treaties. And as we're all familiar with, the Court of Justice did not hesitate to apply these conditions very strictly. Which brings me to say that the Court of Justice would have hardly any hesitation to reject a withdrawal agreement which would encroach upon its own powers, its own monopoly to interpret EU law. So, for the withdrawal agreement to meet this first prerequisite, namely compatibility with EU primary law, its content must not encroach upon the powers of the court. The dispute settlement mechanism, which might be established by the withdrawal agreement, cannot encroach upon the powers of the court, and more generally, the sacrosanct principle of autonomy of EU law, which the Court of Justice has been so adamant to protect, and which the European Council and other protagonists of Article 50 have recalled on several occasions. Otherwise, ignoring this principle might lead to an EEA scenario. I mean by this, the draft agreement being rejected by the court, the way the Court of Justice rejected the first draft of the EEA agreement, precisely because the dispute settlement mechanism which was envisaged there did not comply with the basic requirements which had been highlighted by the court. And that concludes my first section, the UK will therefore very likely have to accept that the ECJ cannot altogether be excluded from the operation of the withdrawal agreement, particularly in view, again, of the fact that many of the provisions of the withdrawal agreement refer to EU law directly. And that brings me to the second requirement, i.e. the reference to EU law directly suggests or confirms that there is an awareness of the requirements that the withdrawal agreement should respect the acquis in establishing the terms of the withdrawal of the UK. The EU mandate, which derives from Article 50 of the TEU, is to set out the arrangement of the withdrawal of the member state that has triggered the procedure. And in this task, the mandate of the EU is to preserve the integrity of the EU legal order, both substantively and institutionally. The mandate of the EU under Article 50 is certainly not to change the acquis and establish a new relationship with the departing state. Withdrawal, in sum, should be as little damaging as possible to the EU legal order. Any modification which might be envisaged of existing rules through the withdrawal agreement should be limited to what is absolutely necessary, if not indispensable, to make withdrawal possible. Indeed, it would be paradoxical that the process of withdrawal of a member state would lead to a modification of the acquis when the accession of new state is premised on full respect of existing rules. Now, as I said on several occasions already, the draft withdrawal agreement refers to several provisions of union law. The arrangement governing withdrawal, therefore, are set by an explicit reference to existing EU rules rather than intending to modify them. If you look at the citizens' part of the withdrawal agreement or several separation issues, there are references both to treaty provisions but also to lots of secondary legislation of the EU. So the intention is to make sure that the relevant rules of EU law continue to apply and govern the withdrawal process for as long as necessary. Now, one thing is to ensure that the substance of these rules is there reflected in the withdrawal agreement. But another thing is to make sure that when they are applied in the specific context of the withdrawal agreement, they are interpreted and implemented in a way that is in line with the way in which they operate within the EU as such. And this entails that beyond a reference, a textual reference to EU legislation, that the interpretation and application of those rules that are mentioned and thus applicable in the UK post-Brexit take into consideration possible evolution of these rules within the Union, and in particular the interpretation of the European Court of Justice, but also possible legislative arrangement or adjustment. So the withdrawal agreement, alongside reference to EU rules, and thus the acquis, should also secure a degree of dynamism in the way in which these rules, which are referred to, are going to apply once the withdrawal agreement starts to be enforced. And that raises the question of methods of interpretation and application of the draft withdrawal agreement provisions, which, as you all know, is still subject to agreements. The parties still haven't agreed on these methods of interpretation and application. They have only, on the whole, agreed on these methods in relation to essentially the citizens' rights specifically. The parties have agreed on which elements of the acquis should be applicable, and they have agreed on the governance of this. They have agreed on a system to secure an homogeneous protection of these rights post-Brexit. Given the time, I will not go into the details of this. But if we go to other provisions of the withdrawal agreement, i.e. outside the citizenship or the citizens' rights part, many of the other provisions are still not covered by an agreed method of interpretation and application of the rules, and that is concerning, of course, because without an agreement on the effect of those rules, including the references to EU law, as well as their interpretation and application, the provisions which are included in the separation part of the agreement, just to give an example, are not going to operate properly. They're not going to work. So the parties will have to agree on this method. And there again, EU law has something to say about the kind of interpretative rules and application rules that should apply in the context of the withdrawal agreement. The parties have still not agreed on the legal effect in the UK that the referred rules of EU law should have once the withdrawal agreement enters into force. And without an agreement on this, then I don't see how the withdrawal agreement will operate. Let me just turn to another potential difficulty raised by the withdrawal negotiations with regard to the preservation of the acquis. And that has to do with the preservation of the of the integrity of the single market, which has been a recurrent concern in the process. The negotiator-in-chief has repeated time and again that the integrity of the single market has to be protected. Now, paradoxically, it would appear that the single market acquis might well be impeded by the draft withdrawal agreement, at least if it is not supplemented by additional instrument. The single market covers not only the EU member states, but includes 3 additional states, the 3 EFTA states which have concluded the European Economic Area Agreement. Now, the arrangement envisaged by the draft withdrawal agreement, which concern the single market, are deemed to apply to the EU27 and the UK, but so far there is no particular arrangement to extend the guarantees foreseen by the withdrawal agreement to the 3 EFTA states in areas which are relevant for the functioning of the EEA agreement. That includes the part on citizens' rights. That includes the part connected to market, to the goods put on the market before the end of the transitional period. That's only 2 examples. There are many more. Now, if the withdrawal agreement is not supplemented by appropriate arrangement to extend mutatis mutandis all the guarantees which the parties, the UK and the EU, have agreed upon to secure the integrity of the single market, paradoxically, the draft withdrawal agreement will introduce a fragmentation of that single market because the 3 EFTA states, nationals but also their goods, will not be taken into consideration in the application of the withdrawal agreement. Now, it's been proposed that all these implications of the withdrawal agreement, of the Brexit for the 3 EFTA states should be covered by parallel arrangement between the UK and the 3 EFTA states. While that might ensure a substantive homogeneity between the arrangements envisaged by the withdrawal agreement to secure the integrity of the single market and the arrangement between the UK and the 3 EFTA states, it will fail to secure an equivalence in terms of governance, i.e. in terms of protection of the rights in the arrangement between the UK and the 3 EFTA states. I'm happy to come back to these issues, but it would be quite a paradox that the EU, that has been so adamant to protect the integrity of the single market in the withdrawal negotiations, will actually, through the conclusion of the withdrawal agreement, introduce some fragmentation of the single market because it would fail to extend to the 3 EFTA states the kind of guarantees which are EEA relevant. The Council a couple of days ago formally authorized the UK to negotiate parallel arrangements with the 3 EFTA states to sort out the implications of Brexit for the 3 EFTA states. And I think this is problematic. I think that the implications for the EEA of Brexit should be dealt with in the EEA context, and the EU should secure that, because this is about the integrity of the single market. I'm coming quickly to my third, I'll be brief, my third point. The withdrawal agreement must contribute to the EU's objectives. It should not only respect the acquis and obviously EU primary law, it should also contribute to the fulfillment of the EU's objectives. This has to do with the fact that the withdrawal agreement has to be looked at in the broader constitutional context of the EU. The negotiations take place in the context of Article 50, but they also take place in a wider constitutional context of the European Union. And what I mean by this is that the objectives that the EU has vis-à-vis third states in general, and the objectives that the EU has in particular with respect to its neighbours, have to be taken into consideration not only in the context of the withdrawal negotiations, but also to pave the way for a future relationship. That brings me to 2 things. First, the objectives of the EU with respect to the neighbourhood, as per Article 8 of the Treaty on European Union, and the mandate that it establishes for the EU to develop a special relationship with the neighbourhood or neighbouring states with a view to establishing an area of prosperity and good neighbourliness based on the values of the Union, this normative framework should frame the way in which the EU not only negotiate the Brexit deal with the UK, but also envisages its future relation. And more specifically, that should frame the type of declaration the EU is going to put together as an annex to the withdrawal agreement. Basically, what I'm suggesting is that Article 8 and the EU's objective vis-à-vis the rest of the world should frame the way in which this declaration should be drafted. The European Parliament has flagged up this point in various resolutions, but to me that has not been very much reflected as yet in the documents coming out of the European Council or from the negotiations. Having said this, I would suggest that this declaration, which has to be annexed to the withdrawal agreement, and that should present the framework of the future relationship between the EU and the UK, that declaration should not be too detailed. We run the risk currently to be dragged into negotiating the future relationship between the EU and the UK. This is not the purpose of Article 50, and this is where our British friends want to drag us. But this is not the purpose of Article 50. Article 50 is about negotiating the withdrawal arrangement, not about finalizing or agreeing on the fine details of the future relationship. It's not about negotiating whether or not the Chequers plan is going to be okay for the EU. This declaration is supposed to set out the broad framework of the future relationship, not the fine details. That would prevent the withdrawal negotiations to be hijacked and potentially torpedoed by considerations that have to do with post-Brexit issues. But there's also a legal point. As I said, Article 50 is about negotiating the terms of the withdrawal of one of the member states. It is not about establishing the new agreement with that former member state. For that, there are other legal bases, other legal framework and procedures that will have to be followed. And for that, you will also need a bit more time. You will need the Commission to figure out what kind of potentially new partnership the EU wants. That's the prerogative of the European Commission in all areas except for the CFSP. This is not the prerogative of the European Council, as per Article 50. And these constitutional requirements will have to be followed. So in short, the withdrawal agreement has to pay attention to the EU's objectives in general and in relation to its neighbours in particular. That should be by reference to these objectives that the declaration should be drafted. But this declaration cannot be too detailed. It cannot be an excuse for starting negotiating the future relationship, because legally there are other frameworks for that. To sum up, the first prerequisite requires that the withdrawal agreement stands judicial scrutiny, i.e. the Court of Justice should be happy that the content of this withdrawal agreement is compatible with the EU treaties, which might be indeed an invitation for the European Parliament to ask the Court of Justice to give a legal opinion on the content of this withdrawal agreement to avoid any problems in the future. Although time is getting very short for this kind of request, and some lawyers would say, well, a preliminary opinion of the Court of Justice on the compatibility of the agreement is not foreseen in Article 50. I would submit the opposite, but there we are. The second prerequisite basically requires that the withdrawal agreement preserve as much as possible the integrity of the EU legal order, and that includes the integrity of the single market, which means that the EU has to make sure that the deal with the UK with respect to EEA relevant part is applicable mutatis mutandis to the three EFTA states as far as the treatment of their nationals who have exercised their right in the UK is concerned. And last but not least, the withdrawal agreement must lay the foundations of a new relationship that correspond to the objectives of the EU, most particularly with respect to its neighbouring states, as per Article 8. Thank you very much for your attention.
Thank you indeed very much. We have 10 minutes. I would suggest that we ask questions, because that's the purpose, to clarify as much as possible doubts or issues that you would like to understand better. But if we make long statements, then there is no time for questions. I have, can I get the list? So Elmar Brok was the first. Yes. Elmar and coordinators. Yeah, we have for EPP, Elmar Brok. Then we will have socialists, whoever is.
Sorry, Joe, but I would like to listen to your words too. I have one consideration I had never so clear, that we have to look into the European Economic Area guarantees. That is always back in our mind, but I think not clearly enough. Thank you very much for that advice, and also completing my position that Article 50, the framework, has to show the direction, but not the solution of the future framework. But I have one question towards the Irish border. It was quite complicated for my Westphalian mind, but nothing of all what I heard was very promising if I compare to the practical possibilities. We have at the moment, let's think it, not really deeply grounded. We have at the moment in the harbours of Belfast and Dublin already now checks about the food questions, about these sanitary problems and all that. That is happening already now. If this would be increased for goods in a certain practical, technical way, without considering this as a border in the sense of international law, keep it really down, could that be a practical solution to think in such a direction to overcome the problem with the Irish Sea? And it's both in Belfast and Dublin.
Thank you very much. For the socialists, I don't know who speaks. Coordinator, please.
Ja, danke für. Thank you for your presentation. We hear the parties agree to the level of 95%. It sounds like we're moving towards the objective, but it sounds like the 5% are the most important, where the outer border of the single market is, whether it's in the Irish Sea or in Ireland. And neither of those options seem to be acceptable. So that does seem to be a stumbling block. The second question I have to Professor Hillion, who said quite rightly, we need to make sure that in the future we need to protect the work and the acquis of the European Union. Environmental associations are coming to me asking about what's going to happen to environmental regulations, but that's something that we can apply to consumer protection and others. So we need to look at how the work and the acquis of the EU extend beyond Brexit. Now, you touched upon Article 8. We cannot allow a neighbour to become a dumping country where social and environmental standards are eroded in order to create increased competitiveness. That's not something that we can accept. We are trying to bring countries up to regulatory levels in the Balkans, etc. We cannot allow a country which has respected such levels to move towards social and environmental dumping.
Sorry, I would just call it. For ECR, there's nobody who would like to speak, I understand. For ALDE, there is nobody who would like to speak. Then I have for GUE, anybody wanted to speak? No, then we go to Greens and Madame Kapp.
Fantastic. Thank you very much. Thank you for your presentations. I'd like to address my comments mostly to the Northern Ireland border issue. Obviously, I'm a Brit, so I hear an awful lot of this day after day in the media. And the really surprising thing to me, given the way our political system works, is that neither of the main political parties, neither the government or the opposition, have proposed anything which actually is possible within the treaty law, as I understand it. So on the Conservative side, we have the Chequers Plan, which clearly undermines the single market in various ways, as Mr Barnier has made very clear. Then Labour have come forward with an alternative proposal, which they say addresses the Northern Ireland issue, because they're suggesting some form of customs union. But I think from what you said, and I'd be grateful if you could confirm this, that Labour's plan also will not address the Northern Ireland issue because they are not accepting sufficient of the acquis and the common rule book. So my question, I mean, that's one question, if you could clarify that. But I'm also interested to know whether you were surprised that Davis, early on in the negotiations, accepted the sequencing as proposed by Barnier and also accepted the Irish backstop later on in December, because surely this was always going to lead us into this situation of impossibility. So do you think he didn't understand at that point what he was doing, or, you know, was there a cunning plan behind all of that? And finally, I'm very interested in what you said about what was happening between 1939 and 1952, because it seems to me, far be it from me to try and solve the government's problems, you know, I'm still trying to stop Brexit, so, you know, I don't want to help them out of the hole, but it's interesting to think that between 39 and 52 there was some sort of separation between what was conceived of as sovereignty in terms of Ireland, North and South, and things like custom checks and passport checks. So I'd be interested in hearing whether you think there might be some kind of resolution there if we stop confusing the issue of these checks with the actual question of sovereignty. Thank you.
Thank you very much. So I understand for EFDD nobody, for ENF nobody, so we can move to non-attached. And then I have Madame James and Madame Dodds.
Thank you very much, Madam Chair. Well, thank you both, gentlemen, for very, very good presentations, particularly the latter. And I don't mean to favour that particularly, but it was a lot clearer in terms of the legal issues. Please, though, could you respond with how is the European Union able to defend its position when the United Kingdom has made a huge concession for the 3+ million EU citizens living in the United Kingdom, and the European Union has not budged 1 inch, 1 iota, for the 1 million+ living in European member states? If you could put the answer in the context of some of the areas that you outlined, that would be very helpful. And I value your legal opinion on that. Thank you.
Madame Dodds, yeah.
Thank you, Madam Chair. Well, as I look around this room, I am actually the one person in this room who lives beside the border between Northern Ireland and the Republic of Ireland. If I get into my car and drive for 15 minutes, I will have crossed the border. I crossed the border to come to Brussels, to go to Strasbourg, to visit family, and I also crossed the border, our family crossed the border to go to work. So having a border that is accessible and easy and viable for people to come and go and to continue with their daily lives is incredibly important to me and to the communities that live around that border. However, I just want to, and I know you've said not to make any statements, but I beg your latitude in this. One of the things that I think we should be very careful about is invoking the peace process or the threat of violence in terms of the border. The border that most people see and the watchtowers that most people see were actually there to prevent Semtex from crossing the border. They were not there to prevent milk powder from crossing the border. And there is a very, very huge difference. And I know that communities north and south of that border abhor the idea that violence in any shape or form would return. I want to specifically address my questions really in relation to trade. In my party, we have set out very few red lines, but the one red line that we are absolutely adamant about is that the withdrawal agreement should not compromise the constitutional and economic integrity of the United Kingdom. And therefore it seems to me that actually the backstop as proposed by Michel Barnier in the European Commission would actually contravene that red line, in that Northern Ireland would be considered to use the backstop language as part of the customs territory of the European Union. Now, for the European Union quite rightly says it wants to support the Belfast Agreement, but actually in setting out the backstop in language like that, it contravenes the central plank of the Belfast Agreement, which is the consent of the people of Northern Ireland to actually belong to either stay within the United Kingdom or otherwise. And I would like your comment on that particular issue. You also said in your presentation that you actually viewed the backstop as a proxy, and I'm quoting because I wrote it down, for discussions on a future trade agreement, which seems a little bit away from your colleague's presentation, which said that the backstop and the withdrawal agreement could not be about a future trade agreement. And I'd like you to clarify that, because many in my community see it as a ploy to keep the United Kingdom in the customs union and the single market. Can I just make one other point, Madam Chair, and I do beg your indulgence. I do think that your suggestion that the 4 freedoms in total should be included within that protocol would be incendiary in the extreme.
Sorry, we still have George and Mercedes. Can you just be 1 minute persons? Thank you.
Thank you very much, and I will be very brief. Professor Hillion, did I understand this correctly, that you said that the ECJ could quash the withdrawal agreement? If I understand this right, how would this be triggered?
Mercedes, quickly, also shortly.
Yes, I can be very brief, because one of my questions was the very one that George has just asked. Is it possible that it would be rejected later? That is, if we don't ask for it before this, could one party request this, and that, of course, would show up the incompatibility with European law ex post after the event? And then my second question for Professor Hillion: in your view, the European Union made a mistake by not immediately, straight away, including the 3 EFTA states, or is it also negotiating, if you like, on behalf of those states? Because if they want to stay within the common market, if you like, the internal market, then they have to accept the agreement as such. So would they have to ratify it ex post? I'm just trying to understand the procedure, because if they weren't involved from day one, from the start, they mightn't be that happy. I hope they have been involved straight away.
For both professors, just I don't want to limit you, but we are already biting into next point on our agenda. So if you could just, whoever wants to speak first, René.
All right. I try to address the issues that were raised with regard to the Irish-Northern Irish border. Now, first, the clarification on, I called it a proxy discussion on the future. This point is not contradicting statements made by Professor Hillion on Article 50, because both parties agreed on the fact that for Northern Ireland there should be a solution after the expiration of the transition period. It is the only element of the withdrawal agreement that will survive the transition period. So if there is no future trade agreement, it will be always there. That's the only element that will always be there in case there is no solution found between the UK and the EU for the future. Therefore, it has elements in it that, of course, give a glimpse on how the future can look like. And that's the reason why I say the protocol will be a benchmark for the future trade agreement, because the parties will know, the UK will know, a part of its territory, Northern Ireland, will have a certain treatment that will be different than the one on the rest of the United Kingdom. So either the free trade agreement aligns with this, and then there will be no frictions between Northern Ireland and the rest of the United Kingdom, or there will be a difference. And when there is a difference, then we are back to the discussion of what to do in the Irish Sea. So therefore, if there is a future trade agreement, then the protocol is gone. But the protocol will, until there is a trade agreement, serve as a benchmark, and by that it has an impact on the future. Hence, this is an element that is part, or that can be seen as a proxy discussion for the future. Now, the point with the constitutional integrity, the UK unity, the integrity of the internal market. As I have said, if you put both principles next to each other, it is hard to come to any solution except for, guys, please stay all in the European Union. And that is a bit the point. The working basis for the 1998 agreement was that both Ireland and the United Kingdom are members of the European Union with individual rights that are guaranteed by EU law. It was not foreseen that this is ever gone. So therefore, we are in a situation that now things have to be decided. And I believe, and that was raised by another comment, one should also see that if we have a different set of rules in relation to product standards in Northern Ireland and the rest of the United Kingdom, then this is a different cup of tea than speaking about the sovereignty and the unity of a country. This brings me to the point that Elmar Brok raised. And I think this is, let's say, if we go into practical points, indeed there are currently already checks. If the European Union side is fine with, let's just do something about these checks, and then we have some sort of soft border between Northern Ireland and the Republic of Ireland, and all parties agree to that, I believe this is a solution that can be found. But that's less for me to answer and more for the negotiators to answer whether that is a way forward. I believe that can be a way forward, and that's a way that one could go to. Quickly on the point, customs and regulatory divergence. Yes, this is the point. The debate is a bit much obsessed by customs and ignoring the issue of regulatory divergence. And if you solve customs and do not address regulatory divergence, the issue of border checks will still be there. And that's the point where you're right. If Labour only addresses customs but not regulatory divergence, it is also no solution, I must say. What Davis thought when he agreed to December, I don't know. What I know is that, what the UK government in December agreed to has a language that was quite open. When reading this, it was not clear in which direction we would ever go to, and I believe that May is right. She agreed to something where she didn't think that the protocol that in the end came out was actually meant by it and had a different impression of what it is. The language of the December was quite contradictory, if I may say so. As little clarification on 1939 to 52. That was only in relation to persons. So it was a situation in which the UK made tougher immigration rules because of the war. And after 1945, there was no adjustment of these immigration rules. Now, as a consequence, if you change immigration rules, the very basis of the common travel area is not there anymore. So you have to make you have to make checks of free movement of persons. And therefore, back then, the UK government said, if we want to be serious with our own rules, then we also have to check the travel between Northern Ireland and the rest of the British Islands to have an effective control of our own immigration rules. So in that time, it was basically a solution that had to be done in order to deal with the war situation. Whether that can then be used nowadays is a different point, but it shows we are not speaking about separating Northern Ireland from the United Kingdom. We are speaking about some rules, in particular in relation to goods, that might be different, that require then certain kind of checks wherever they are to be established. And I believe it would be very helpful for the debate to separate sovereignty from this set of rather technical rules in relation to goods and customs.
Thank you. Christophe?
Yes, thank you. On the rights of the British citizens, indeed, at the outset, there seem to be some kind of imbalance, and you may be referring here to the fact that the initial draft withdrawal agreement did not recognize that British citizens having exercised their free movement right would be able to keep their free movement right post-Brexit, i.e. the possibility to move from one member state to the other. I have the feeling that there's movement on that to the effect that this free movement right might be recognized, but the language is still not entirely clear. So I would agree with you that one needs some clarification on this. But with respect to the other rights, it seems to me that I mean, there's some balance there, equality between the rights which British citizens, having exercised their right pre-Brexit, and those of EU citizens. I mean, those rights seem to be equally applicable. So there have been problems of consistency in the past, but I think those problems are being addressed. At least there is a movement in that direction. How would the Court of Justice quash the agreement? This is not an agreement between the states of the Union, among the states of the Union and the withdrawing states. This is an agreement of the EU as such, as you know, negotiated by and concluded by EU institutions. And so this agreement and the way in which it's negotiated and concluded must comply with EU rules. The way EU external agreements have to be negotiated, concluded in accordance with the procedure of Article 218, and in terms of substance must also comply with canons of EU law, including the Charter of Fundamental Rights. Now, I see two avenues, one ex ante and the other ex post. The ex ante is still a bit controversial because there has been this argument that the only reference to Article 218, sorry to get technical, the only reference to Article 218 that you find in Article 50, 218 being the treaty-making procedure, is paragraph 3. There's no specific reference to paragraph 11, which entitles the European Court of Justice to give an ex ante legal opinion as to the compatibility of a draft international agreement negotiated by the EU and the treaties. I would humbly submit that this legal opinion, this avenue, this mechanism is available in the context of Article 50, at least implicitly. When you look at the way in which Article 50 has been implemented, articulated by the institutions, you see that it's not only paragraph 3 that has been used in a way in designing the procedural framework for negotiating the withdrawal agreement. There are additional mechanisms which have popped up which refer to other paragraphs of Article 218. So in practice, there are other dimensions of Article 218 that have been brought into the negotiation of the withdrawal agreement. And I see no problem going all the way and bringing in the legal opinion of the court as per paragraph 11. That's one element. The other element is that the very purpose of that ex ante legal opinion is to prevent problems for the European Union once the agreement is concluded. If the agreement was concluded and therefore the implementation of the agreement was started, and if it was discovered thereafter that there was a problem of compatibility between the agreement and EU primary law, then the EU will get into troubles. Which brings me to the second avenue. It's possible ex post to challenge the conclusion, the decision whereby the Council concludes the agreement, either on the basis of Article 263, you have a 2-month time limit whereby the privileged applicant under Article 263, member states, but also EU institutions can challenge the legality of the agreement, but the non-privileged applicant, citizens, legal and natural persons, can also challenge the decision, albeit on the very, very strict conditions established by the court. Now, if we think of our EEA national friends, if they are not covered by the kind of guarantees that the EU offers to EU citizens and UK citizens post-Brexit, why not mounting a case against the Council conclusion on the ground that it violates the provisions of the EEA agreement? And then The alternative would be later on in the context of a preliminary reference to the Court of Justice where the validity of the decision concluding the agreement could be questioned. So you have several avenues, and it is within the realm of possible that some lawyers somewhere might think that there are certain provisions in the withdrawal agreement that actually are problematic from the point of view of EU law. Now, with respect to the EFTA states, I have this view that several parts of the withdrawal agreement, which is an EU act, it's not like the Treaty of Accession, an instrument of EU primary law. The withdrawal agreement is not an instrument of EU primary law. It falls under, because it has to be compatible with EU primary law. My humble submission is that there are several parts of this withdrawal agreement that are so-called EEA relevant. Now, of course, what we used to in terms of EEA relevance are directives, regulations, decisions which specifically relate to the functioning of the internal market. But nothing in the EEA agreement, in my view, would oppose an EU act such as the one we are faced with, namely an EU agreement, to be EEA relevant too. And indeed, if you look at the content of this withdrawal agreement, there are several elements which are EEA relevant, at least insofar as many EU legislations which are referred to in the withdrawal agreement have been incorporated into the EEA agreement, which in my view is an illustration of the fact that they have some EEA relevance. Now, if that EEA relevance is correct, that in principle should have opened up the possibility for the EFTA states to exercise their decision-shaping rights up front. Thank you. This has not been done for various reasons, but this is past. And indeed, they have been involved in very informal ways in these negotiations. Michel Barnier visited Norway, and the contacts have been regular. But we're not still in a kind of decision-shaping rights we were talking about. My view is that what is considered EEA relevant in the context of this agreement should be subject of a joint committee decision for the purpose of incorporating those parts into the EEA agreement. That would guarantee absolute homogeneity between the guarantees which the EU and the UK may have agreed upon in the context of the withdrawal agreement and the guarantees which would then be applicable to the EFTA states' relations with the UK in the context of Brexit. I know it's controversial, both among the EFTA states. This is not the view of some legal services, but I still want to hear the legal argument against this very suggestion that the withdrawal agreement has some EEA relevant parts which should be incorporated into the annexes of the EEA agreement.
Thank you to both of you. Thank you very much. I think you have you are leaving us with a lot of sort of stuff for reflection, and also taking into account where we will be working also on our procedure for the consent. So I think it was extremely useful. I would like to thank you once again, and let's hope we can be in touch also with you for the next month. Thank you indeed very much.